Hello, and thank you for joining us for today's webinar on global privacy developments in Europe, Asia, and the Americas, which is part of our lineup of presentations this month for National Cybersecurity Awareness Month. Privacy developments have been evolving rapidly over the past year in several jurisdictions worldwide. In today's webinar, we'll provide an overview of some of these major developments, including the impact of Schrems II and Brexit on data transfers, the LGPD coming into effect in Brazil, developments concerning the California Consumer Privacy Act and the proposed California Privacy Rights Act, and the Chinese Cybersecurity Law. We look forward to providing an overview of these developments and what we see coming down the road. My name is Lei Shen, and I'm a partner in our Cybersecurity and Data Privacy and Technology Transactions Practices in Mayor Brown's Chicago office. I am joined today by 4 of my colleagues from some of our offices worldwide. Karen Lee is a counsel in the IP and TMT group of Mayor Brown in Singapore, and is part of the firm's global cybersecurity and data privacy practice. Her focus is on commercial and non-contentious IP and TMT matters, as well as data privacy. Cristiane Mensueto is counsel in the Brazil office of Mayor Brown and heads the data privacy practice in Brazil. She has been engaged in the intellectual property field for 14 years. Ulrich Worm is a partner in the Frankfurt office of Mayor Brown and heads the German intellectual property practice. His practice focuses on technology-related advice. And Oliver Joros is a partner in the intellectual property and IT group, as well as the technology transactions and cybersecurity and data privacy practices of the London office of Mayor Brown. He advises clients on technology and outsourcing transactions with a particular focus on fintech and digital transformation projects. Before we begin, I would like to mention a few housekeeping announcements. At the bottom of your screen, you will notice there are multiple application widgets you can use. Answers to some common technical issues are located in the Help widget. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off your VPN or Citrix connection is recommended. If you're applying for CLE credit, you will need to record the alphanumeric code provided during the program on the affirmation form found in the Resource List widget. Also in the Resource List widget is a PDF of today's slide deck. This webinar is being recorded, as we normally do with these programs. In a day or so, we will be sending you an email with a link that you can use to listen to the webinar again or share with your colleagues. The recording will also be posted on our website. Finally, if you have any questions that are unanswered during the presentation, we invite you to submit them using the Q&A feature on the left side of your screen, and we will do our best to follow up with you directly after the webinar has concluded. Now I'll turn it over to Ulrich Worm and Oliver Joros to discuss developments in the EU and the UK.
Thank you very much, Lei, for the introduction. My name is Ulrich Worm. I'm a partner in the Frankfurt office of Mayor Brown, and I'm going to talk about the Schrems II decision. And my colleague Oliver Joros will then follow up to talk and give an update about Brexit. To start off, I'm going to talk about the implications of the so-called Schrems II decision of the Court of Justice of the European Union. In very broad terms, the decision concerns data transfers from Europe to third countries. More specifically, the decision concerns data transfers from Europe to the United States of America on the basis of the EU-US Privacy Shield or standard contractual clauses. By way of quick recap, data transfers from Europe to a third country are only admissible if they are based on at least one of the so-called safeguards listed in Article 46 of the GDPR. These safeguards include an adequacy decision, which, broadly speaking, confirms that a level of data protection in the country to which the data shall be transferred is adequate. Binding corporate rules, which provide for legally binding data protection rules for data transfers between members of a group of undertakings, and standard contractual clauses. If none of the safeguards in Article 46 GDPR is available, transfers may, but only by way of exception, be based under strict conditions called derogations for specific situations. Such derogations are listed in Article 49 of the GDPR. In practice, however, since these derogations are exceptions to the rule that transfers must be based on one of the safeguards under Article 46 GDPR, data transfers can hardly be justified under the derogations in Article 49 GDPR. Against this background, many companies relied on the so-called EU-US Privacy Shield and/or standard contractual clauses for their data transfers from Europe to the United States of America. In the Schrems II case, the court was asked to ascertain whether the Privacy Shield, which aims to establish an adequate level of protection in the United States, is a valid basis for data transfers from Europe to the US. The court decided that the Privacy Shield does not establish an adequate level of protection in the United States and can thus no longer be used to transfer personal data from Europe to the US. This decision follows the previous so-called Schrems I decision, which held that the predecessor to the Privacy Shield, the so-called Safe Harbor, also did not establish an adequate level of protection in the US. In Schrems II, the court further held that standard contractual clauses continue to be an instrument under which transfers of data from Europe to a third country can be justified. However, parties wishing to rely on standard contractual clauses must verify, prior to any transfer, whether the level of protection in the third country is in fact adequate. The court pointed out that appropriate supplementary measures in addition to standard contractual clauses could be implemented in order to protect the data if such measures ensure that foreign domestic law in the relevant third country does not impinge on the adequate level of protection. The court, however, has not elaborated which supplementary measures should be taken. The European Data Protection Board announced that it is looking into this question and will provide further guidance. Because the court held that no adequate level of protection exists in the US, the Privacy Shield can no longer serve as a legal basis for the transfer of personal data from Europe to the US. Whether and under which conditions standard contractual clauses could still serve as a legal basis remains questionable for the time being. So, what does this mean for companies which have relied on the Privacy Shield or the standard contractual clauses to transfer personal data from Europe to the US? Well, first of all, transfers to the US and other countries which do not offer an adequate level of protection need to be suspended immediately, unless and until the transfers could be based on another legal basis. There is no grace period which will apply for transfers going forward. Further, companies will need to conduct due diligence on the laws in the jurisdiction of the data importer to ascertain whether such laws offer an adequate level of protection. In the case of standard contractual clauses, companies should consider to implement supplementary measures in order to protect the personal data that is to be transferred. In particular, companies should consider to implement end-to-end encryption. Companies should check whether the encrypted data could be hosted in Europe or another safe country instead of being transferred. and it should be evaluated whether data could be anonymized or at least pseudonymized where possible. Since, at least at present, it is unclear whether such supplementary measures would be sufficient and whether the derogations could now be relied on more broadly, companies need to closely follow further developments, in particular regarding the announced guidance from the European Data Protection Board on supplementary measures and transfers post-Schrems II. Companies should also evaluate whether the data transfer could be based on another legal basis. In particular, companies should consider whether the transfer could be based on the consent of the data subject and evaluate whether the derogations could provide a legal basis now that the rule to which the derogations may only be an exception no longer applies following Schrems II. Where possible, companies should consider switching to service providers or invest in data processing infrastructure, personnel, in Europe or a third country that is regarded as being safe based on an adequacy decision of the European Commission. In this context, it is worth noting that the CNIL, which is the French Data Protection Authority, has recently issued a recommendation that parties handling health data should not use US-based service providers, even if such US providers would store the data in Europe. The CNIL apparently fears that US authorities could access such data even if the data remains in Europe and is thus not exported to the United States. It's apparent that the CNIL recommendation goes beyond what Schrems II says, and it remains to be seen whether other European data protection authorities will adopt similar positions. We will keep you posted on developments. With that said, I will now hand over to my colleague Oliver Jaros from our London office. Oliver will provide an update on Brexit and recent EDPB guidance.
Thank you, Ulrich. We now move on to another topic which relates to data transfers, this time between Europe, the European Union, and the UK. As you may know, the UK left the European Union at the end of January this year. Because of that, the UK is now treated as being a third country as far as the EU GDPR regime is concerned, meaning that a mechanism or safeguard or derogation would otherwise be required to transfer personal data from the EU to the UK. Fortunately, for the remainder of this year, there is a transition period, which means that European Union rules still apply in the UK, which means that personal data can still flow to the UK from the EU in the same manner as it had done while the UK was a member state of the European Union. But of course, that raises the question as to what happens following the end of the Brexit transition period at the end of this year, 31st of December 2020. Well, the UK is going to have a UK version of the GDPR, cleverly named the UK GDPR, and this will sit along the Data Protection Act 2018 to have rules on how personal data should be processed in the UK. There's going to be very little difference between the EU GDPR and the UK GDPR. There really are just technical amendments that's been made to allow the UK GDPR to work in a UK-only context. But of course, this does raise the question of how data can then flow to the UK from the EU following the end of the transition period. Well, the hope is that the European Commission will provide an adequacy decision for the UK by the end of the year, which will mean that data can continue to flow from the EU to the UK following the end of the transition period without organisations having to put standard contractual clauses in place or other safeguards or rely on any of the Article 49 derogations that Ulrich mentioned just now. But of course, It is no means assured that the European Commission will provide an adequacy decision, and Schrems II has outlined some of the concerns which the European Commission might find when looking at UK laws and UK safeguards that would allow data to continue to flow safely. And some of the laws that have been touted as perhaps causing problems include the UK Investigatory Powers Act, the right of the security organisations within the UK to look at data, and also onward transfers that are conducted from the UK to the US under bilateral data sharing agreements between them. Nevertheless, it is the hope that an adequacy decision will be reached, but we will not know until near the end of this year whether that will in fact happen. So organisations need to watch this space and be ready to put in place mechanisms that will allow data to continue to flow between the EU and the UK, whether that's by putting in standard contractual clauses or looking at derogations, should an adequacy decision not be forthcoming. For its part, the UK government has said that transfers from the UK to the European Union or broader EEA will continue to be permitted after the Brexit transition period has ended. One additional development that we wanted to mention during this presentation was some proposed guidance issued by the European Data Protection Board in September. The EDPB has issued some guidance on the meanings of controllers, processors and joint controllers under the GDPR, and this has been proposed for public consultation until the end of October, following which, at the end of that period, the guidance will be updated and formally adopted by the EDPB. This guidance is very important because it updates the position on the circumstances in which the EDPB thinks that an organisation will be a controller, processor or joint controller under the GDPR. Briefly, a controller is the party which determines the purposes and the means of processing personal data, i.e. the why and how of the processing, whereas a processor only acts on behalf of the controller within the boundaries that the controller sets. Two parties or more can be joint controllers if they determine the purposes and means of the processing jointly. These new guidelines provide some very helpful clarifications to organisations about when they might be acting in any of these capacities. Importantly, they identify and distinguish between determining the essential means of processing, which is reserved to controllers, and determining the non-essential means of any processing activities, which are decisions that processors can take while still remaining processors. It's important to note from the guidance that not every service provider that uses personal data may be a processor. They may well be a controller or even joint controller with another organisation. And entities can simultaneously act as a controller and as a processor for different processing activities. The development from this guidance is important to consider because historically parties often thought of themselves just as either separate controllers or processors in any relationship and didn't often think about joint controllership. However, what the guidelines suggest is that many organisations are likely to be acting as joint controllers in a number of the processing activities they might be conducting within their group or with third parties. As a result, we expect to see a higher number of scenarios of joint controllership going forward. In advance of the guidelines being finalised, organisations should review their relationships and contracts with third parties and even group companies to ensure that the sharing of personal data is in accordance with data processing agreements and joint controllership agreements that reflect and document the likely roles and respective responsibilities that the parties should occupy to comply with the GDPR. That concludes the update of European developments for this presentation.
Good morning, good afternoon, or even good evening, depending where you are right now around the globe. First, I need to say that I'm happy to share with you some relevant highlights and key aspects regarding the LGPD, the new Brazilian data privacy law. Well, after 2 long years of discussions and surprises regarding the extensions and no extensions on the effective date of this law, the LGPD is finally in full force since September 18, 2020. On a side note, the DPA, the Data Protection Authority, is not yet implemented in Brazil. Just for your reference, recently, the members were indicated, but are still to be approved by Federal Senate, which means that until now, we just have the letter of the law and no guidance, neither regulations, due to the essence of the DPA so far. Definitions, principles, and scope. Of course, there are key differences, which some of them will be addressed on the next slide. Regarding the scope, as the GDPR, the LGPD has an extraterritoriality scope. In this sense, the LGPD is applicable to any processing performed by natural persons or entities, regardless of the means, country, or headquarters where the data are located. In practical terms, the LGPD applies to any processing operation carried out, regardless of the location of the business and if the individual are Brazilian citizens or not. If any of the following apply: all processing operations that occur in Brazil, all processing activities related to the offering or provision of goods and services for individuals located inside Brazil. So even if a company is not established in Brazil, the LGPD applies if that company offers goods and services to individuals in Brazil. Also, the LGPD applies to all processing activities related to individuals located inside Brazil, or all personal data collected when the data subject was inside the Brazilian territory. So as I just mentioned, in these circumstances, companies located outside of Brazil, in Europe or in the US, for instance, must comply with the LGPD. Certainly, the DPA will issue some guidance to the interpretation for the extraterritoriality scope. For instance, the DPA may clarify what can be considered of offering or provision of goods and services, if it's that just a marketing place or not. In this slide, I'm going to talk about the LGPD enforcement and the fines. The LGPD may be enforced by the data subject, the Brazilian Data Protection Authority, public prosecutors, consumer defense organizations, and other authorities. It's important to say that even before the LGPD entered into effect, we have been facing lawsuits, investigations by the public prosecutors, consumer defense and authorities, based mainly on consumer code and internet civil framework. The penalties of the LGPD are issued exclusively by the Brazilian Data Protection Authority, the DPA. The fine can be of up to 2% of revenues in Brazil in the prior financial year, up to a total maximum of 50 million per violation, which today would be approximately $250 million of USA dollars. There is also the possibility of a daily fine to compel the entity to cease violations. As of the administrative sanctions, I will cite 2 relevant ones: the suspension of the data processing activity related to the infringement for the period of 6 months, extendable for another 6 months, and the partial or complete prohibition of activities related to personal data. These administrative sanctions will only come into force only in August 1st, 2021. And of course, if until then, we have the DPA indeed established. In any event, this does not mean that companies cannot be fined so far, since we have penalties established in Code of Consumer Defense and Internet Civil Framework applicable to protection of personal data. Well, let's go to the key points of the LGPD. Similar to the GDPR, an organization must have a valid basis for processing personal data. This means that personal data can only be processed if it meets one of the 10 different lawfulness of processing established by the LGPD. 8 of them are related to sensitive data. We will jump to the main lawfulness of processing and hypothesis in the next slide. Under the LGPD, the international transfer of personal data is permitted to countries or international organizations that ensure an adequate level of protection of personal data. Since we do not have the DPA so far, we cannot rely on either one of these possibilities: adequacy decision, binding corporate rules, standard contract clauses, and certification. So until now, since we do not have the DPA, it's important to bear in mind that for the international transfer of personal data, the entity will need to rely on specific consent, performance of a contract, legal or regulatory duty, exercise rights in a lawsuit, arbitral in administrative procedure. Another point that is relevant to mention is we also have the transparency principle. It's also a paramount for Brazil. Hence, it's really important to inform data subjects in a clear, adequate, and ostensive manner. Secure personal data from any incident is another principle of the LGPD. Therefore, companies need to secure the integrity and confidentiality of the personal data. This being said, it's important to perform a risk assessment, guarantee cybersecurity controls based on the state-of-the-art technology. Following the accountability principle, documentation is also relevant and can mitigate penalties. We draw your attention for these relevant materials: records of processing activities, the ROPA, contracts with joint controllers and processors, and data protection impact assessment, DPIA. Just a quick note that ROPA and DPIA are mandatory documents according to the LGPD. As to the main legal basis, I will start with the first, fourth, and fifth legal basis indicated on the slide. So the first one, because they are very clear to understand. So the first one is you can, of course, process the personal data to comply with a legal or regulatory obligation. The fourth is you can process a personal data or necessary, which is necessary for the performance of a contract with the data subject. And the fifth is you can process the personal data to exercise rights in lawsuits, administrative or arbitral proceedings. Well, let's go to the other legal basis. So we have the consent, which needs to be freely given, unambiguous, and informed by the data subject. We have the legal basis of legitimate interest, which is really a gray zone since until now we have no guidance from the DPA. We have the protection of credit, which is a very specific legal basis for Brazil. We do not see this legal basis worldwide. Well, again, since we do not have an authority so far, we recommend avoiding using this legal basis in a broader scope. Just for a reference, we have a specific law in Brazil regarding the credit bureau, which performs core credit activities in Brazil and are authorized by the government. We can also see another legal basis that allows an entity to process personal data to prevent fraud or for the safety of the data subject by means of an electronic authentication system. For instance, biometric, which is a sensitive data, which is very useful for banks. So this is really a legal basis for protection of credit, prevents fraud, which is currently used by banks. Now let's talk about the data subject rights. Brazilian residents have a number of rights over their personal data. Many of these rights are similar to those found in the GDPR, such as deletion of personal data processed with the consent of the individual, correction of incomplete, inaccurate, or out-of-date personal data, anonymization, blocking, or deletion of unnecessary or excessive data or personal data not processed in compliance with the LGPD, portability of personal data to another service or product provider, and information about the possibility of denying consent and revoking consent. In addition, the LGPD also introduces rights not included in the GDPR, such as access to information about entities with whom the organization had shared the individual's personal data, access to information on whether or not the organization holds particular data. Another key point of the LGPD, and which is different from the GDPR, is that the controllers are obliged to designate a data protection office DPO, whether a natural person or legal entity. It's worth to mention that after the DPA is established, it may be possible that designating of a DPO may not be mandatory for companies that process data occasionally or have a small size. Well, let's see what is to come, right? Another relevant point to mention regarding the LGPD is that to comply with the data subject rights, the LGPD establishes 15 running days to provide a complete copy of all the personal data that the company processes. All other hypotheses of complying with data subject requests are established by the law as immediately. So the entity, sometimes depending on the type of data subject that they are requesting to comply with, the deadline is immediately, which is quite difficult to comply with. In this sense, the DPA might give some guidance here regarding immediately deadline. According to the LGPD, we have a broad concept of security incidents. So security incidents can be loss, unauthorized access or use, breach, data leakage, and cyber attacks. Communication to Data Protection Authority and data subject is needed only if the incident results in a risk or a relevant damage to the data subject. And this communication to the DPA shall be done within a reasonable term. Again, we expect that DPA may establish this reasonable term. I would like to end this conversation saying that as private law changes and global compliance requirements are top of mind for our clients operating worldwide, we will provide timely updates on the LGPD and any DPA guidance issued to keep our clients abreast of further developments. I'm glad to be part of the firm's cybersecurity and data privacy team, since the GDPR experience of my colleagues in Europe will be definitely very useful for Brazil. And now I will turn it over to Lei Shen, our data privacy partner based in Chicago, to discuss developments in the U.S., specifically the CCPA and the CPRA. Thank you.
Thanks, Christiane. There have been a lot of privacy developments in the United States in the past year, mostly involving in some way or another the California Consumer Privacy Act, or the CCPA, and the wave of proposed copycat laws that it triggered, including the California Privacy Rights Act, or the CPRA. For those of you who aren't familiar with the CCPA is considered to be the most sweeping privacy law in the United States. Unlike other jurisdictions like the EU, the United States does not have an overarching data privacy law. Rather, data privacy laws in the United States are generally more limited and are focused on specific industries, such as those in the financial or healthcare industry, or specific types of data, such as social security numbers or financial account information. This structure is slowly starting to change now after the passage of the CCPA. The CCPA became effective on January 1st of this year and became enforceable by the California Attorney General on July 1st. It applies to for-profit companies that are doing business in California that meet certain criteria. Since doing business in California is fairly broad and doesn't require the company to have an establishment in California, the CCPA actually has an extraterritorial effect and can apply to companies in other states or even in other countries. In addition, the definition of consumer is also very broad and means any California resident, which also captures employees and business contacts in addition to consumers. However, the CCPA was recently amended to exclude employees and business contacts from the scope of most of the CCPA obligations until January 1st, 2022. There are still a few obligations that apply to employees, though, which we'll discuss on the next slide. Unlike other U.S. privacy laws that came before it, and more similar to the GDPR, the CCPA provides consumers with certain rights to their personal information, including the right to know, the right to opt out of the sale of personal information, the right to delete, and the right to not be discriminated against for exercising these rights. In connection with these rights, the CCPA imposes a number of obligations on businesses. Among these obligations are notice-related requirements. Specifically, businesses have to provide a notice to consumers at or before the point of collecting their personal information. This notice at collection must indicate the categories of personal information to be collected and the purposes for which that personal information will be used. This notice must be made readily available where consumers will encounter it at or before the point of collection, whether the personal information is being collected online, offline, or over the phone. However, if the business does not collect personal information directly from a consumer, then it doesn't need to provide that consumer with a notice at collection as long as it doesn't sell the consumer's personal information. It's important to note that providing the notice at collection is one of the few CCPA obligations that still apply for employee data. Or in other words, this is one of the few obligations that are not excluded by the employee data exemption. This means that employers that are subject to the CCPA must provide their California-based employees and job applicants with a notice at collection that describes the categories of personal information to be collected and the purposes for which that information will be used. Businesses also need to provide a privacy policy to consumers. And the main difference between the CCPA privacy notice and the CCPA privacy policy in terms of content is that the privacy notice describes the information that is about to be collected, whereas the privacy policy describes the information that was collected in the prior 12 months. In addition, the privacy policy must identify the sources from which the personal information is collected, the purposes for which the information is collected or sold, and what personal information is disclosed or sold to third parties. The privacy policy must also provide a description of the consumer's rights, among other requirements, and also be posted online through a conspicuous link on the business's website homepage. The CCPA provides consumers with a few GDPR-like rights as well, although these rights still differ from those under the GDPR. One of these rights is the right to know, where a consumer has the right to request the categories and specific pieces of personal information collected by the business about the consumer in the prior 12 months. In responding to such a request, the business must confirm receipt of the request within 10 business days and then disclose and deliver the relevant personal information free of charge within 45 days of receiving the request, although it may extend this time frame by another 45 days. Another right is the right to opt out of the sale of personal information, which doesn't have a direct corresponding right under the GDPR. Under this right, a consumer may direct a business to not sell their personal information to third parties. As part of this right, a business must provide a clear and conspicuous link on its homepage titled "Do Not Sell My Personal Information" that directs the consumer to a web page where they may opt out. A business must comply with an opt-out request within 15 business days. Consumers also have the right to request deletion of their personal information that the business collected from the consumer. There are a number of exceptions that apply here, though. For example, a business does not need to delete the consumer's personal information if they need to retain that information to complete the transaction for which the personal information was collected, or if retention of the information is reasonably anticipated within the context of the business's ongoing relationship with the consumer, or if it needs to retain the information to comply with a legal obligation, or even if it retains the information to use it internally in a lawful manner that is compatible with the context in which the consumer provided the information, which is fairly broad. There are other exceptions as well. And the same time frames for responding to a request to know also apply to a request to delete. Finally, consumers have a right to not be discriminated against for exercising any of these CCPA rights, such as being denied goods or services. If a business violates the CCPA, the California Attorney General may impose fines of up to $2,500 per violation or $7,500 per intentional violation, which may add up quickly depending on the number of consumers that are involved. Businesses have 30 days to cure the violation. Consumers also have the right to bring a private right of action under the CCPA. However, this private right of action is limited to certain types of data breaches rather than any violation of the CCPA. The CCPA tasked the Attorney General to develop regulations that would establish rules and procedures on how to comply with certain provisions of the CCPA. The CCPA regulations provide a number of detailed requirements and procedures supplementing the CCPA that businesses should review. For example, they provide detailed requirements regarding what needs to be included in the notice at collection and how to provide it, and also detailed information on what needs to be included in the privacy policy and how the privacy policy should be provided, which businesses should review when drafting privacy policies. The Attorney General came out with a few drafts and released its final version of the CCPA regulations on June 2nd, which it submitted to the California Office of Administrative Law, or OAL, for approval. The OAL approved the regulations on August 14th and made a few revisions to the Attorney General's version, releasing a final version of the regulations. The OAL also approved the AG's request to make the regulations become effective and thus enforceable immediately upon filing. A few days ago, though, on October 12th, the AG yet proposed more changes to the final regulations. These changes focus on opt-out of sale requirements, clarifications to the authorized agent requirements, and clarifications regarding notices to consumers under 16 years of age. The AG is currently accepting comments on these changes, so they are not yet final nor enforceable. The Attorney General was authorized to begin enforcement of the CCPA on July 1st, and it promptly sent out on that date initial compliance letters to allegedly non-compliant businesses. These letters tended to focus on businesses that operated online and that either failed to provide key privacy disclosures required by the CCPA or failed to include the Do Not Sell My Personal Information link where the Attorney General deemed it to be necessary. Some of these businesses were identified after the Attorney General reviewed their online policies, and others were identified from consumer complaints, including those that were made through social media sites such as Twitter. The Attorney General has indicated that he intends to focus future enforcement actions on protections for minors and other vulnerable populations, and also on the sale of personal information. With this current flurry of activities surrounding the CCPA, there is already a CCPA version 2 that's being proposed that will amend the CCPA. The California Privacy Rights Act, or CPRA, will be on the California ballot next month. If it is passed, it will create new and additional rights and obligations in California. For example, the CPRA would establish a new category of sensitive personal information, which would include a person's social security number, driver's license number, passport number, financial account information, precise geolocation information, race, ethnicity, religion, union membership, personal communications, genetic data, biometric or health information, and information about sex life or sexual orientation. The CPRA would give consumers certain new rights regarding the use of this information, including providing consumers with the right to limit use and disclosure of such information to just those functions that are necessary for the business purpose for which the information was originally collected. The CPRA would provide California consumers with the right to request the correction of their information that's held by a business if that information is inaccurate. The CPRA would also prohibit businesses from collecting additional categories of personal information or using personal information for new undisclosed purposes unless it has given the consumer prior notice. In addition, it would require businesses to minimize the collection, use, retention, and sharing of personal information to what is reasonably necessary to achieve the purposes that the business disclosed. One of the anticipated benefits of the CPRA is the extension of the employee and business-to-business exemptions to January 1st, 2023, which would allow time to address the employee and B2B privacy questions in a separate bill. The CPRA would also establish the California Privacy Protection Agency to enforce the law. The CCPA, by contrast, is currently enforceable by the California Attorney General's office. There are a number of other changes as well, including the expansion of the publicly available information exemption that's currently available under the CCPA, new disclosure requirements, and also an expansion of the right to know. If the CPRA is approved by voters next month, it will become effective in December, but it actually won't become operative until January 1st, 2023. There will also be a 6-month grace period for enforcement, similar to what happened with the CCPA. So enforcement wouldn't begin until July 1st, 2023. And until then, the CCPA would remain in full force and effect. I'll now turn it over to Karen Lee, who will provide us with updates on developments in Asia.
Thank you, Leigh, for the introduction. So I will now be discussing the regulations in Asia, so providing a bit of an overview. So of course, Asia is quite a broad region, but I will be focusing first on the evolution of some of the regulations in Asia in the last 5 or so years, some upcoming regulations as well, highlighting some of the issues relating to data privacy in Asia and the trends in data privacy in Asia. I'll then just do a bit of a focus on China and some of the recent developments, as well as on Hong Kong, and then ending with some takeaway points. In the last 10 years, we've seen a real evolution in the data privacy laws in the region. Between 2010 and 2015, there was a lot of laws that were enacted, data privacy laws that were enacted for the first time. So for example, in the Philippines, Taiwan, South Korea, Malaysia, and Singapore all enacted their first data privacy legislation. Hong Kong as well has had data privacy laws in place since 1996, but in 2012, 2013, they amended the personal data privacy laws to tighten the regulation on the use of data privacy in direct marketing. In terms of the last 5 years, there's been a real focus on cybersecurity. The most well-known of which is the China Cybersecurity Law, which came into force in June 2017, which also impacts how companies use personal information, as well as what they call important data. I'll discuss China Cybersecurity Law a little bit later on. Other countries that have also been looking at cybersecurity legislation is Thailand, Singapore, and Taiwan, for example. This year, many countries have been proposing amendments to existing data privacy laws. The real focus has been on mandatory data breach notification requirements and cross-border transfer restrictions, as well as enhancing the powers of the regulators and increasing the fines that may be imposed. Also, some of the last major countries that have not yet implemented an overarching data privacy law have submitted a data privacy bill for consideration, so for example, India and Indonesia. So one of the clear problems with the Asia-Pacific region and data privacy is that if there's a patchwork of data privacy laws, there's no one consistent law that applies, obviously, throughout the region. Every country has their own requirements regarding consent and notification and direct marketing. Also, different requirements on breach notification obligations, whether it's mandatory or voluntary. Also, cross-border transfer restrictions, whether or not data processes are directly regulated or not. Data retention requirements, even the definition of data, personal data, whether or not you have separate categories of sensitive data, for example, and the restrictions that surround sensitive data or biometric data. And obviously, we also have different data privacy regulators depending on the country. So it makes it quite difficult sometimes to coordinate and to make sure that you're compliant with all the data privacy laws in the region. Each country has their own level of restriction. Some are a bit more lenient than others. Korea, for example, is extremely stringent in regards to consent and notification requirements. Hong Kong is a little bit more straightforward. But even though the region is made up of a patchwork of different laws, one thing we can definitely see in the last year or so is an overall greater alignment in the standards across Asia towards a gradual shift towards a more GDPR-esque standard. Mandatory data breach notification requirements is also something that's been particularly focused on by the regulators, wanting to introduce that and make it mandatory. Increasing penalties for data privacy breaches and also tying it to more revenue-based penalties, same as how they do with the GDPR. There's also been a greater emphasis on accountability-based frameworks, so making sure that not only data controllers, data users are held accountable for any personal data breaches, but also data processes. There's also been a great emphasis on making sure there's an approach of privacy by design and introducing the requirement for personal impact assessments. So now I want to focus a bit more on China, which has raised quite a few concerns amongst clients over the last couple of years since the new cybersecurity law came into place in 2017. So for China, there's no overarching data privacy law. It's sort of a patchwork of miscellaneous laws that may apply. The cybersecurity law is the one that's sort of the closest to an overarching data privacy law currently. It applies to both personal information as well as important data. What counts as important data, though, is something that's still not clear, and we're still expecting more guidelines to be provided in relation to it. But essentially, it's data relating to that can affect national security. How they'll interpret that and how broadly they'll interpret that remains to be seen. The cybersecurity law applies to network operators and CII operators, so critical information infrastructure operators. Network operators is actually defined very, very broadly, and it could have the potential to apply to essentially any company that operates or uses a computer system in China or has a website in China, which is essentially every single organization in China. The cybersecurity law actually applies to a broad range of businesses. Some of the main concerns with the cybersecurity law are the data localization requirements. So under the CSL, CII operators must store in China personal information and important data that's been generated or collected during its operations within China. There are also cross-border transfer restrictions. So you can't transfer or provide access to personal information or important data offshore unless certain requirements are met. For example, conducting an official security assessment that would be conducted by the appropriate regulatory authority, obtaining consent, having certain contracts in place with the recipients of the data. It's still not clear exactly what these requirements are. The latest measures in relation to them are still in draft format and have not been finalized. So whether or not the current format of the measures will be brought into operation, or there'll be more changes to be introduced, remains to be seen. There's also a multi-level protection scheme under the cybersecurity law, which prescribes certain security requirements that need to be implemented depending on the level of risk of assessed in terms of a company's risk level. There's also something known as the Personal Information Specification. Amendments to the Personal Information Specification actually came into effect just this month. The PI specification is essentially best practice standard for personal information security. So it's not per se mandatory or binding, but it is something that is strongly recommended to be complied with and is taken into account by the regulatory authorities when assessing whether or not there's been sort of any breach of the cybersecurity law or any other data privacy laws. In July this year, the draft data security law was issued in China for public comment. It applies to any data activities that occur not only within the borders of China, but as well as those carried out by individuals and companies that are located outside of China, as long as their activities would allegedly damage China's national security, public interest, or the legitimate interest of its citizens. It's intended to apply to both electric and non-electric records of information and to a broad range of data activities. So data collection, storage, processing, usage, provision, even transactions, even selling data and publishing data. So some of the proposed requirements introduced by the draft data security law include enhanced protections of important data. So a multi-level data protection scheme, which is quite similar to what is already found under the cybersecurity law, where different security requirements will apply to data that falls into specific levels of risk based on their assessed importance to social and economic development and harm to national security. Local governments authorities and industry regulators have to draft a catalog of what they perceive to be important data that will be subject to these enhanced requirements. And processors of important data will need to conduct risk assessments and appoint data security officers and designate a management department to oversee the handling of the important data by the data processors. In addition, the draft data security law allows the Chinese government to take countermeasures against what they perceive to be restrictive or discriminatory trade and investment measures relating to data or data development technologies that are being imposed against China by foreign countries. In addition, they cannot, data processors cannot provide any data to any foreign law enforcement authorities unless it is with the prior approval of the Chinese authorities. So for any data that's actually stored in China, if a company receives a request for access to that data by a foreign law enforcement authority, they must first get the approval of the Chinese local authority before they can release that data to a foreign law enforcement authority. This, of course, can raise certain issues in terms of conflict of laws, complying with, for example, a law in the US or the EU, which requires you to provide access to certain data to regulatory authorities there. But you also have this conflicting regulation under the draft data security law, which means that we need to get the Chinese authorities' approval beforehand. But it's not really clear what would happen in situations where that approval is not forthcoming. So hand in hand with considerations about China come considerations of Hong Kong and their data privacy laws. So Hong Kong actually has one of the oldest data privacy regimes in the Asia-Pacific region. It came into force in 1996 and was amended once back in 2012 related to direct marketing requirements. It's also due for another round of amendments next year. Some of these proposed amendments include introducing a mandatory data breach notification requirement, a requirement to have in place data retention policies, the direct regulation of data processors. Currently, only data controllers, or what we call data users in Hong Kong, are regulated under the Personal Data Privacy Ordinance. The proposals also seek to expand the definition of personal data and also to regulate against doxing and increase the penalties that can be imposed for breaching the data privacy law. One of the laws in Hong Kong that has been receiving a lot of attention lately is, of course, the National Security Law, which came into effect in June this year. The National Security Law creates new offenses of secession, subversion, terrorism, and collusion with foreign or internal forces, and it's also an offense to aid, abet, or assist in the commission of such offenses, including providing financial assistance or funds. What has raised some particular concerns amongst companies is the broad powers that are provided to law enforcement agencies in Hong Kong. This includes being able to require anyone that's suspected of having any information or material relevant to an investigation of one of these offenses to provide it or to answer questions that are posed to them that are relevant to the investigation. It also grants law enforcement agencies the power to search relevant premises and also electronic devices that may contain evidence of one of these offenses. The power to conduct interception and surveillance, but that has to be approved by the chief executive. The interception and surveillance would only be in relation to a person that's suspected of committing one of these offenses. The law enforcement agencies can also require service providers or individuals to remove information. For example, requiring them to take down any posts on social media. And they can also be required to provide any other assistance requested by the law enforcement agencies. Most of these powers can actually only be exercised under the issue of a warrant, except in certain emergency situations. In conclusion, there's definitely been an increased awareness of privacy rights in Asia, which has led to an increased adoption of overarching data privacy laws and a trend towards more regulation. There's definitely been increased enforcement through constant updating of laws and regulations. As I mentioned, Hong Kong, Australia, Singapore, New Zealand, for example, have all been looking to update their existing laws to make it more in line with the standards that are now expected of countries in light of the GDPR. There's also increased focus on cross-border data transfers and having more restrictions in place to protect personal data. Those countries that don't have overarching legislation currently will also likely have ones in place in the next year or so. For example, India and Indonesia. China as well is looking to introduce its own data privacy law. Thank you for tuning in. I hope you enjoyed it, and if you have any questions, please feel free to reach out to us directly.